Happy New Year. My name is Chris Guthrie. I'm a professor of law and the dean of Vanderbilt Law School. On behalf of the school, it's my pleasure to welcome you all to the 2012 Dr. Martin Luther King Jr. Memorial Lecture. This lecture is the law school's contribution to the university's annual celebration of Dr. King's life and legacy. For making this lecture possible, I would like to thank Associate Dean Lisa Bressman, the Dean's Office staff, the Black Law Student Association, and our law school event staff. In December 1962, nearly a half century ago, Dr. King delivered an important address at Vanderbilt Law School. In his lecture, which he entitled "The Ethical Demands for Integration," he argued that the problem of race and color prejudice remains America's greatest moral dilemma. When one considers the impact it has upon our nation, its resolution might well determine our destiny. History has thrust upon our generation an indescribably important task to complete a process of democratization which our nation has too long developed too slowly. Our speaker, whom it is my pleasure to introduce, has devoted his lifetime in a variety of ways to the process of democratization that Dr. King described nearly 50 years ago. Judge DeArmey Bailey, Vanderbilt's 2012 Martin Luther King Jr. lecturer, is a practicing attorney, a former member of the City Council in Berkeley, California, a former Tennessee Circuit Court judge, a founder of the National Civil Rights Museum at the Lorraine Motel in Memphis, an actor who has appeared in such movies as The People vs. Larry Flint and How Stella Got Her Groove Back, a published author, and perhaps most centrally, a committed civil rights activist. In his most recent book, The Education of a Black Radical, Judge Bailey describes his experiences as a young activist and leader during his college years at Southern University in Louisiana and Clark University in Massachusetts. He concludes this book by reflecting on his decision to go on to law school, ultimately graduating from Yale. When I went to Louisiana and became involved in the sit-ins, Black lawyers gave us their guidance, helped us to develop strategies, and represented us when we were in jail. They demonstrated an ability to analyze and strategize, to survive by learning the rules and turning them to their advantage. I have never envisioned a life without activism. For me, the law was a tool that would help me survive and grow as an activist, equipping me for yet more battles to come. Will you please join me in giving a Vanderbilt Law School welcome to Judge Bailey.
Thank you very much, Dean Guthrie, and I want to express my gratitude to your staff and to your faculty and students for your gracious courtesies in inviting me and hosting me here at this great university. Before I get into the body of my remarks, I want to reflect, since this is the occasion of Dr. King's birthday celebration period, a book that I will commend to you, written by Professor Vincent Harding, that's titled Dr. Martin Luther King Jr., The Inconvenient Hero. And Professor Harding talks about Martin Luther King in the context of how we have visualized him as the Martin Luther King of 1963, when he gave the March on Washington speech and talked about black children and white children getting together and us overcoming the last vestiges of racism in America. By 1968, when Dr. King was killed in Memphis, however, he had reached quite a change in his perspective and in his approach to the struggle for liberation in America, and had recognized that not only was it a struggle for civil rights, the right to sit at integrated settings, in the lunch counters and in the schools and on the buses, but also the more pressing and challenging demand of the struggle for economic justice and the need for some basic change and reordering of American society and priorities. The poet Edwin Markham wrote, "There is a destiny that makes us brothers. None goes his way alone. All that we send into the lives of others comes back into our own." Now you are about to embark on your own destiny in the noble field of practicing law. You will serve as advisors, advocates, and negotiators. Many of you will be hustling to get ahead in a competitive firm. Many of you might open your own law firm and experience the 24/7 headaches and challenges of running your own business. I'm here today to talk about the other part of being a lawyer. You're an officer, of course, of the legal system and a public citizen having special responsibility for the quality of justice. I cannot tell you what that should mean to you, but here's what it has meant to me. To begin with, one must have a recognition of who you are, how you see yourself, and what road do you travel as you find your way in life. For me, it was a time of a civil rights journey. I grew up as a young kid in Memphis in the 1940s and 50s, particularly as a high school student, as a teenager. At the time when America was going through the most dramatic change that this country had seen in the area of race relations, probably since the Reconstruction period. And I don't mean that those changes were for the good. During the post-Reconstruction era, when we had the advent of the Klan and lynchings and terror groups on into the early part of the 20th century. But as I grew up as this kid in a segregated Memphis where the schools were segregated, where the amusement park we could only go to one day a week, and if that day was a holiday, we couldn't go. We'd have to wait until the next week, or to the movie theater where we had to go all the way to the balcony. I was blessed to be in an era when people were about to rebel against that system, that order of things. When black people in the late 1950s, certainly in my own community, began to organize, first to enter the political process by running people for office. Memphis was a little bit different from a lot of southern cities because blacks didn't have a great difficulty in voting. It was simply that the black vote in Memphis was controlled by a political machine, the Crump machine. But blacks voted, and so by the time the Crump machine came to its end in the mid-50s, blacks had a tradition of voting. And so we began to see blacks organize and try to support white candidates who were not segregationists, more liberal candidates, candidates like Ross Bass, who was a senator from Tennessee, Estes Kefauver, who was a senator, and other candidates, George Grider, who was a congressional candidate who was, I can't say they were pro-integration, but they were not segregationists. And my brother and I, who were high school students in the late 50s, would go to the meetings where they were organizing the political efforts, and we would see the strategies being developed by the NAACP. But what struck me particularly was the role that the handful of black lawyers in Memphis were, the roles they were playing in helping to devise the strategies of protest against the established order in Memphis. First, in helping to groom and and recruit candidates, helping to organize political campaigns. So black lawyers were taking the role early on, not simply as practitioners of the law, but as key leaders and strategists in helping to develop and unfold a movement to change the order of race relations, not only in Memphis, but across the South. And having that early exposure to those black lawyers, and then going, as I did as a freshman in 1959, down to Southern University, the nation's largest all-black school. And little did I know, as a 17-year-old going off to school, that I was stepping off into the beginning of a true revolution, the Civil Rights Revolution, because it was in my freshman year at Southern that the students in North Carolina at Greensboro in February of 1960 went to that lunch counter and refused to move, and were arrested and set off a spate of similar protests on black college campuses across the South. And a month later, on my own campus at Southern, other black students went out and protested by sitting in at the segregated lunch counters, and they too were arrested. In fact, some of the most significant constitutional decisions to have come out of the Supreme Court came out of the protest activities of some of these young people. One leading case that was decided was the case of Garner versus the state of Louisiana, where those students who were arrested in 1960 at Southern, their cases went all the way to the Supreme Court, and because they were prosecuted for breach of the peace. And the notion was that by their going and sitting at the segregated lunch counters, that this would cause others who were against their protest to attack them. And so therefore, by their precipitous conduct, they were breaching the peace. And the Supreme Court, in overturning the convictions of those students, found that to be an unacceptable rationale. And in that case of Garner, when they overturned the convictions of these Southern University students from the 1960 protest, the court made particular note of the history of Louisiana having to do with race relations, and it talked, Justice Douglas did particularly, about, well, I'll just quote just briefly from that opinion, where he said, "But in Louisiana, racial problems have agitated the people since the days of slavery. The landmark case of Plessy versus Ferguson, the decision that announced in 1896 the now repudiated doctrine of separate but equal facilities for whites and blacks, came from Louisiana, which had enacted in 1890 a statute requiring segregation of the races on railroad trains. As the first Mr. Justice Holland stated in dissent in Plessy versus Ferguson, in view of the law, there is in this country no superior dominant ruling class of citizens. There is no caste here. Our Constitution is colorblind." And then Justice Holland, in that opinion, went on to say that, quote, "There was more to the conduct of these petitioners than a bare desire to remain at the white lunch counter and their refusal of a police request to move from the counter. We would surely have to be blind not to recognize that petitioners were sitting at the counter where they knew they would not be served in order to demonstrate that their race was being segregated in dining facilities in this part of the country. Such a demonstration in the circumstances of these two cases is as much a part of the free trade of ideas as is verbal expression, more commonly thought of as speech." And so the conduct of these young kids reverberated all the way to the highest chamber of justice in Washington, where they expanded on the view of freedom of speech to cover and protect the protest rights of these young people, and help to serve as a foundation of legal protection for the many protest demonstrations that were to follow, not just protest demonstrations around race, but as we know, in later years, protest against the war in Vietnam and other matters that caused us great concern, as people believing in social and racial and political justice. By the time I was in my third year of school, things had quieted down at Southern, and the students protested again in 1962 because segregation was continuing even though the criminal convictions had been reversed. And with the continuing desire and unrest among our young people, you see, we were the first of our generations to go to college, most of us. And we, in these classrooms at these segregated campuses, were being taught concepts of justice and freedom and equality and fairness, and yet living in a society, in a community, that was a direct contradiction of those precepts. And so, as young people, it's hard for one to put on blinders and not be engaged to somehow challenge those contradictions and to stand up against the powers of authority. I learned, therefore, at a very early age that one has a responsibility and in some ways a destiny if one has any kind of conscience and any desire for personal freedom, let alone the broader freedom of one's brothers, that you're caused to be engaged. So at Southern, students went and protested again because segregation was continuing. And we marched en masse to downtown Baton Rouge to carry our protest to the heart of the commercial city, the commerce of the city, Louisiana, Baton Rouge being the capital. We passed the state legislature. And I remember, Dean Guthrie, that on that day in my junior year when some 3,000 students marched on a rainy day to downtown Baton Rouge, some had already been arrested as we went downtown. In my book, I write about that experience that day when we got downtown because we were going to protest some of the students who had again been arrested some days earlier, again challenging segregation in Baton Rouge. It is impossible to describe what it feels like to be shot with tear gas. I could say that it makes your skin sting and burn so badly you think it is peeling off your hands and face. I could say it makes your eyes feel as if they had been set on fire, and then it makes your eyes water so steadily you cannot see. I could say that when the harsh, pungent gas fills your lungs, it is as if two great hands have reached up and squeezed your diaphragm, and then placed a bag over your head so you cannot breathe. But these descriptions, while accurate, don't convey the full effect of the experience. Even more difficult to explain is that the anger I felt that December afternoon as the tear gas canisters exploded throughout the streets of downtown Baton Rouge was of an intensity I had never before known. All the hellish years, all the indignity and injustice, all the times a white person had refused to acknowledge me, all the times I'd been insulted, welled up inside me. All those feelings and memories broke through the walls of restraint I had built around them and came together in one hard mass of anger, and some part of me said, no more. Some part of me said, I will not live my life in the back alleyways of the world. And I hardened myself to the fact that though my purpose was good, if I stood by it, anything could happen. The instant Sheriff Clemens hollered, move him out, one of the deputies threw a tear gas canister that struck Reverend Cox on the ankle as it exploded, knocking him to the ground. As several students rushed to carry Cox to safety, canisters exploded in quick succession up and down St. Louis streets. Confused and hysterical, we all began running, blindly trying to escape the swirling gas. Shoes, umbrellas, and purses littered the streets. I could hear the unmistakable barking of police dogs and the whining of the sirens, mixing with the almost overwhelming noise of students' screams, scattered singing, and the sharp explosions of the tear gas canister. Of course, there was nothing to do but run, to run as fast as you could and to try not to wipe your eyes because, as I found out too late, that made it worse. As I ducked down the nearest alley, I reminded myself that I had known that this was a possibility before I had agreed to come. I reminded myself that the police could and would get away with whatever they decided to do. I tried to convince myself that I had known and expected these things, but I hadn't, not really. I hadn't known I would be so afraid. I hadn't known about the dogs or about not being able to breathe. I hadn't known what it would feel like to wonder, as I ran with the police at my back, if they might use those shotguns and if the bullets might hit me. But I ran anyway. I ran down alleys and tried to catch my breath in the doorways of buildings. When a cloud of gas overwhelmed me, I closed my eyes and groped my way along the nearest wall. I ran looking for safety and fresh air. And I felt that though I might eventually find some air to breathe, I would never be safe anywhere. I hated that feeling, but I hated the white police more. Reverend Cox was an organizer who had come to help us and was arrested that day. And his case also went to the Supreme Court. And the conviction of Reverend Cox was demonstrated. And this was another issue of law that faced the court because they charged, among other things, that he had broken a law that banned demonstrations around the courthouse. And the court wrestled with that, and it was a 5-4 decision in Cox versus Louisiana that reversed the conviction of Reverend Cox. But it was essentially a sympathetic court that was looking for some way to show its appreciation of the constitutional right and protection that we demonstrators had. Because, in fact, the Supreme Court said, Dean, that by the police allowing us to go on, they had implicitly agreed that we could demonstrate, and therefore it sidestepped the issue of banning demonstrations at the courthouse. But that was yet a second case that had gone from the streets of Louisiana to the halls of the Supreme Court and came back with that decision. Now, I was expelled from school as a part of the demonstrations at Southern in 1962 because this was a state school. And one of the approaches of the leaders was to expel the students, and to do that, they, of course, would lean on the black administrators of these schools and force them to put us out of school. And it was, again, the lawyers. I remember Murphy Bell, a black lawyer in Baton Rouge, Johnny Jones, a black lawyer who still practices there in Baton Rouge, was one of the first blacks who was elected to the legislature in Louisiana. And we would go from Baton Rouge to New Orleans, and there was a black law firm in New Orleans called Collins, Douglas, and Eli that would sit with us and talk with us, would do simple things like take us to lunch at Dookie Chase, which was a relief from being under the intense pressure of the battlefield in Baton Rouge. A.P. Thoreau, one of the deans of black lawyers in Louisiana. So again, as I'm growing and learning and engaged in this process of change, I'm appreciating the dedication. Without these lawyers, they weren't the ones on the marches, they weren't the ones necessarily going to jail, but they were the bulwark of strength and encouragement that kept us young people nourished and protected and feeling not alone as we face these terrible obstacles. And so I have a tremendous understanding of lawyers, not as people who accept the law as it is, but who challenge the law and force it to change. The sacrifices and the dedication of these lawyers, and sometimes it was at the sacrifice of their own safety. Some of them were threatened. I remember in Alabama there was a white lawyer by the name of Chuck Morgan who was outspoken in fighting against segregation, and Chuck Morgan had to leave Alabama because of the threats There was a white lawyer in New Orleans by the name of Bruce Walzer, who was prosecuted and accused of sedition because he and Dr. Dombrowski, Jim Dombrowski, had supported us students. I remember Dr. Dombrowski, though not a lawyer, but working with Walzer and another white lawyer, Ben Smith in New Orleans, was supporting us. And they were arrested, Dombrowski and Bruce Walzer and Benjamin Smith, and they were charged with sedition. And out of that came the case of Dombrowski v. Pfister, again dealing with the rights of individuals to speak up and to go against the system, but challenges that had to find their way all the way up to the Supreme Court before those rights were affirmed. Law students. When I was in law school, we had an organization called the Law Student Civil Rights Research Council that was started in the mid-'60s because we knew that the civil rights lawyers were overworked in places like Jackson, Mississippi, and Birmingham and Atlanta, where these hotbeds of struggle were going on. And so the notion came that what we would do would be to take law students and have them from their campuses around the country to research some of the legal questions and to send that research back to these lawyers on the battlefields in the South and even in some northern cities, but particularly in the South. Thus, the Law Student Civil Rights Research Council. But beyond simply doing the research that this organization, once it got started, and it was funded by private foundations, many of which were doing some of the funding for the more active groups like Dr. King's Southern Christian Leadership Conference and some aspects of the Congress of Racial Equality and even the Student Nonviolent Coordinating Committee, which would have some nonprofit arms that could receive some of that charitable funding, which was so important to carry on those battles. But the law students played a critical role. We would recruit law students from schools from California to New York, about 200 in the summers, and we would send them into the South. And so we had a law student working with Fannie Lou Hamer in Ruleville, Mississippi. We had law students placed in Jackson, Mississippi with Marion Wright Edelman, who was the lawyer on the scene for the NAACP Legal Defense Fund, one of the primary legal organizations carrying on the struggle for civil rights, and in fact, the organization that Thurgood Marshall came to head. We had lawyers in Florida and obviously in Louisiana with Collins and Eli and with Ernest Morial, later the mayor of New Orleans, and other lawyers. One of the things that we had in mind in recruiting these law students, and most of them were white, I met Professor Herder during that time, and Alex Herder in 1967, 68, when I was running this organization out of the New York offices of the American Civil Liberties Union. And he was a law student, and they had the sanitation strike going on in Memphis, and they were fighting in the courts, and I talked with my brother, who was in an integrated firm in Memphis, the first one in Memphis, representing Dr. King and others. And I got a foundation to give us some money to send some law students to Memphis. And so we hired 10 law students, and we sent them from different parts of the country to Memphis to work with the lawyers who were representing Dr. King. Thus, Alex went down to Memphis on assignment through our group. And in fact, on the fateful night that Dr. King was shot and killed, Alex was the first suspect picked up as a potential assassin of Dr. King and arrested because he was a white man at the wrong place and the wrong time, because he was down there working in the black community, organizing. But he was released through the efforts of some valiant lawyers. But he was out there on the battlefield. And, you know, I talk about the role of these law students and BALSA, the Black American Law Students Association, which got started around that same time, because there was there was an unusual thing about the youth of my generation. We did not feel that the older generation was the one that would solve our problems. We felt that if the issues were to be solved, we would have to solve them ourselves. And one of the things that you also have to learn if you're out to solve problems and if you're dedicated to change is that sacrifices will have to be made, because once you get into issues like civil rights, civil liberties, peace, Occupy Wall Street, the issues are very serious issues. If you're challenging authority, power concedes nothing without demand, so said Frederick Douglass. It never has and it never will. He said agitation, agitation, agitation. And so it's the matter of lawyers using that unique training and that ability to find the unwritten about the written rule and to bring that to the surface and to force the challenge that makes us so powerful and so strong in our discipline. Our nation and people without a voice cannot wait until you, as law students and lawyers, are well established and partially retired to be a good public citizen, to help fight the injustices of our system. They need your new ideas and your compassion and your energies now. The title of this speech, Law in the Hands of an Angry God. The Almighty has directed us to do justice and righteousness and deliver from the hand of the oppressor he who has been robbed. I believe that God's wrath is on those who sit back and let people's homes be taken away from them by greedy financial institutions who would rather see our inner cities crumble rather than negotiate with homeowners. I believe that any universal higher power, however you may see it or define it, that you believe in is sick and tired of seeing new plantations today that we call prisons, that house so many of our young men and women, particularly our African-American young men and women, who could have been helped by intervention, by programs, by counseling, by drugs, by training, by job opportunities. I was visiting the county prison in Memphis on a panel with a tour, and we listened to the inmates, and they came up to us and they said, when we get out of prison and we try to get a job, we can't get a job because we got a record. And so if I can't get a job, I've got to survive some kind of way. If I've got a family, I'm going to support that family. So if you can't find work, if the system is set against you because you have made a mistake, then you're going to create another crime. That's just plain and simple survival for some of these, many of people. And unfortunately, and I see it all the time, and that's something that I think that legislatures need to address, is this matter of not being able to get your record cleared. Young people who have made a mistake, whether it's a shoplifting or a burglary or whatever, and this criminal record follows them throughout life because unless you've beat the charge, gotten a not guilty conviction, there's no way of taking it off. And so I believe that God is angry because we as a legal profession today have retreated from addressing these resources that help to make a difference in our society. The questions that we face now are questions of whether we surrender our voice and our talent as lawyers to this overwhelming domination that's getting stronger of dissension and greed sowed by the wealthy, and particularly now that corporations have been given complete freedom to pollute our politics and our communities with lies and innuendos and counterattacks against men and women of goodwill. And just over the past few months of the Occupy movement, we see that things are getting to the point where people are having to again take to the streets. One of the things that I find most rewarding about being a lawyer is that it gives you so many options. You don't just have to practice law. I remember Floyd McKissick, a black lawyer out of Durham, North Carolina, who went on to become the head of the Congress of Racial Equality and was leading the marches with Martin King in the streets of this country. I remember Bill Kunstler, who was helping people like H. Rap Brown, who was being prosecuted in New York. And even in my own career, when I went out to California in 1967, 68 actually, and started practicing law with legal services. Legal services was started with the idea that we would take government money and hire lawyers in cities across the country and undermine the established power and authorities in these cities, with the notion that eventually the government would find out what its money was doing and it would take the funding away. So it was not anticipated that legal services would survive as it was created in its initial days. Gene Kahn and Edgar Kahn, husband and wife legal team, who were two of the primary theoreticians that helped to create the legal services format. This was their view. These were not people who saw their role as lawyers simply to validate and to perpetuate the legal system as it was. To some extent, they saw their role as undermining the legal system as it was in order to force the creation of new systems. There's this Hegelian concept, Hegel, the philosopher, that talks about things going in a cycle, that there's the thesis, which is things as they are today. The poor getting poorer, the rich are getting richer, 99% and 1%. And people begin to get so oppressed and they feel so tightened and hopeless that they rebel. And that creates the antithesis, the revolt. That was the movement of the 60s. And then out of that revolt, and I think that we see ourselves in that period where the pressure is getting greater and greater, even among young people like yourselves who are studying and trying to prepare yourself, that people revolt, and out of revolt comes change. It only comes through revolt. And so then you have the thesis, the change, rather the synthesis, the change that comes out of the conflict, the synthesis. And then again, the process starts again because people get complacent again. And then the whole cycle starts over again. And I think about my own son, who's a lawyer, young lawyer who's with the U.S. Attorney's Office in Memphis, comes out of Washington University Law School with debt in 6 figures, practically. Well, what do? You're a debt prisoner. And so how do you then go out and challenge authority when you know that you've got a monthly note to pay? And if you don't, then your credit gets ruined as a professional. And one of the things that used to have some movement toward debt forgiveness, if you would go into certain areas of work, of community service, we've moved away from that. But I think that there has to be some way of relieving this imprisonment of our best minds and have a trade-off where if you spend so much time, imagine the talent that could be unleashed in these communities that are trying to be rebuilt, in these urban areas where people are so poor and desperate, not just in terms of legal issues, social issues. Barack Obama, one of the things that he had the foresight to do before getting into politics was to go out into the urban areas of Chicago and help people organize. But that will only come to the extent that we guide our forces and our resources to demand that our political bodies, now funding agencies, rethink where our priorities are. And that's going to take a lot more than simply asking for it. It's going to take demanding. Now, lawyers as politicians, you can go into public office. I was on the city council in Berkeley, and I'm going to wrap up to allow some time for some questions. I was on the city council in Berkeley after I got out to California because I saw the opportunity to run for office in Northern California. And once I got elected to the council in 1991 with two others, we would develop alternative budgets, and we would filibuster in the council meetings, and we would use the parliamentary rules to bring the ordinary functioning of local government to a halt. Not to make things work smoothly, but to make them run into stone walls where people would have to then stop and contend with these issues. Now, of course, just as they kicked me out of school at Southern, I was recalled from the city council in Berkeley. But if your objective is to preserve yourself, protect yourself, then you become weakened. Your strength comes from your willingness to stand up and take the slings and arrows and make the sacrifices. In the areas of litigation, I have a case right now. In fact, I say sometimes I'm kind of like Bonnie Fife on Annie Griffith. I got one case like he's got one bullet. But this firm that hired me 2 years ago, they're a nice firm, and they've got 9 offices, Wilkes and McHugh. And they started 25 years ago suing nursing homes, corporations. They don't sue the small ones, they sue the corporations, because they realized that the corporations were making enormous profits with government support of funding through Medicare and the like, and not having adequate staffs in these nursing homes to give the patients the care, to turn them, to watch their hydration, their food. They would fall and have fractures. They'd get pressure sores. They would end up with poisoning of the blood and system, and they'd die earlier. And Wilkes and McHugh developed a system for suing these corporations and made hundreds of millions of dollars. Who would have thought that you could then go and take somebody who's old, who's 80 or 85 years old, and sue and get millions of dollars in recovery? But it's because they attack the corporations and the greed of the corporation. I have a case right now, my one case, where I represent a kid who's a teenager. He was 17 years old, and he was working, they called him in special work overnight at McDonald's in Memphis, black kid. And his white manager, when my kid was supposed to get off at 5 in the morning, the manager shows up at 5:30, the kid tries to leave, the manager says, no, you better clean up, grabs the kid and beats him and bangs his head into a metal counter, and it's all caught on tape. So we sue McDonald's and we sue the assailant, of course, and McDonald's in this case is pending now in federal district court in Memphis. McDonald's then enters and says, you can't sue us because the only remedy for this kid is workers' compensation. Now, figure that. Workers' compensation is the notion that you've got more or less a contractual relationship between the employer and employee, that instead of us having to fight, you're having to prove that you weren't negligent, you get automatic pay, and the corporation gets the benefit that you can't sue them for negligence. Well, with an adult, you might argue that, well, there's a contractual right, and somehow or the other you can superimpose that scheme on adults and limit what they can recover if they're hurt on the job. But with a kid, so the Supreme Court in Tennessee had said, you can't do that with a minor, that a minor can either sue the corporation or it can take work comp benefit. So what does the legislature in Tennessee do? Changes the law. And it says that workers' compensation also applies as the exclusive remedy to a minor, even if the minor is illegally employed. And so the federal judge has granted partial summary judgment on the exclusivity remedy as it relates to the local franchise, it left the corporation in for the moment, and we've got a hearing on that on January 24th. But in the meantime, the Children's Defense Fund, through the leadership of Marion Edelman, is filing an amicus brief, and we're going to file a motion for declaratory judgment to challenge the constitutionality of the Tennessee law that says that minors' only remedy is workers' compensation, because workers' compensation means that the maximum you get is 400 weeks times your average weekly wages. Well, you think of a kid working 20 hours a week, and you multiply that times the maximum that they can recover, no matter how grievously they're injured, and that's all they'll get. And that's been the law in Tennessee since the legislature acted in the 1960s. We've been a half century on the books with that law. And so my point in that example is that there are all kinds of issues that lay beneath the surface of what we take for granted in our everyday lives, that lawyers, now of course, fortunately with a firm like this, they've got the resources to carry on that fight. And it takes resources, it takes money, there's no question about that. And in the past, we had many more foundations that were willing to help than there are now with the financial support for that kind of litigation. And we've got to find other ways of supporting those battles. But in the meantime, do like the law students did when we were working in the 60s. Work for subsistence wages. Now, you can't do that too easily if you got those big debts. So it really is a catch-22 situation for you, and I understand that. How can I say to my kid who's got these loans to pay back, well, son, you ought to be volunteering your time. Now, of course, he is doing work in the public sector with the U.S. government. So maybe there ought to be a movement of law students to sue to cancel his debt. I mean, you never know what kind of judge you might get, you know? That's the point. Try it. Don't ever be afraid to try something. Well, I leave you not with the notion that you can change everything, because you can't. But maybe along the way you can change one thing, one life. Start off by never forgetting to have empathy with your clients. You might find that under similar circumstances, you might have found yourself wearing the same shoes. Another one of my favorite quotes is this, also by Markham. Ah, great it is to believe the dream as we stand in youth by the starry stream. But a greater thing is to fight life through and say at the end, the dream is true. You all stand at the starry stream now. If you fight the good fight, at the end, the dream can be true. Thank you. We have about 10 minutes. I know some of you have classes, and so I won't hold you in contempt. You can go. But those of you who've got 5 or 10 minutes, if there are some questions that you want to ask, then I'll try to answer them. Most of you have class at 1, so thanks for your patience. And all right, question in the back. I'm sorry? Well, the reason I think they're complacent is because the older people who controlled the information, the message, the professors in the universities, the media, have all been sort of homogenized with the theme of leaving things basically in a certain equilibrium rather than in a state of positive agitation and change. I don't think that our teachers and our parents and our older people have that sense of fight. I think that after the changes came, and I think to some extent people got tired. They got tired after the anti-war protests of the 60s. And then suddenly government, you know, Dwight Eisenhower, and now you hear Ron Paul, and I have very little empathy for or sympathy for Mr. Paul, but he tries to build on what Dwight Eisenhower talked about in 1960 as the military-industrial complex. But there is such an overwhelming supremacy of money and power that comes together that controls our media, controls our politicians, that it makes it more difficult for the individual to feel that they can make a difference, and it's easier to go along. That's why I think that what these people with the Occupy, and I know that it's a mixed bag of people. I went to the Occupy site in Oakland when I was out in California in November and visited it there, and I visited the one in Memphis. And I know that you've got people, some of whom are homeless, some of whom may have mental health issues because so many people have been turned out into the streets without adequate mental health facilities and services. But there's deeper than that. There are people who have a real dedication and belief that we must fight back against the increasing control of our society, the undemocratic control of our society, by corporate money and by the handful of people who are getting richer at the expense of everybody else. And so it's going to change because people's paychecks are getting smaller and jobs are getting fewer. And I don't think that it matters that much. It matters in many ways in terms of the leadership of the country as to who gets appointed to the courts, but in terms of the domination of power, George Wallace used to say he didn't think there was a dime's worth of difference between Democrats and Republicans. To some extent, I think that's true, because both parties are basically have allegiance to maintaining the overall economic status quo, not to overthrowing it. And that's where King comes in terms of what I was trying to say about the notion of King, because what King said toward the end was that he used to think that you could make a difference a little bit here and a little bit there. But what King said in 1968 was that now he's come to believe that you have to have a total restructuring of the society. Well, then they wouldn't put that statement on the monument that they just put on the mall. If I'm a judge, I can make decisions that I know are against the grain and are likely to be reversed, but I keep making them if I think they're right. And maybe some other judges will do the same. If I'm a lawyer, I can file litigation. We had lawyers, I think of a lawyer, Lynn Holt, who was down in Atlanta, Georgia. They used to file test cases that were just as novel in terms of theories. If they didn't win, they at least gummed up the works. I think that you must make the functioning much more difficult. You must gum up the works. Now, that's a hard thing for people to comprehend. But that was the nature of the movement of the 60s. It was to bring things to a halt. Derek Bell, who died just a few months ago, Professor Bell, wrote a book called Faces at the Bottom of the Well, The Permanence of Racism. And Professor Bell says that the only time America has made changes that has to do with matters of race has been when it was forced to do so in its own interest. And so I think that you must make the functioning of society in the interest of those who are in power, that they must change. Now, you can't take to the streets. At least we don't have the numbers and we don't have that position yet. But I do think that we ought not to abandon civil disobedience as a tool against authority. And I think that that's one of the things that the Occupy movement. So I think that we must use all of the tools to gum up the works. Now, how do you feed yourself? How do you keep your job as you do that? And that's why I say that you have to be willing to sacrifice and lose your position. You cannot be a good guy and change things. There are enemies, and there are people who will turn back and try to destroy you. But the only thing that can keep you going is that you have faith in the honesty and integrity of what you're doing, so that there will be at least a few people who will probably help. How did it say that a journey of 1,000 miles starts with one step? Well, the same thing is with a movement, starts with one person. And so I don't think you can tell where you may have an impact or not, but you cannot give up and simply feel that you're powerless. You must feel the power within yourself as one, the power of one, to make a difference. And that's where the movement starts.